Welcome to Case by Case. This is a podcast brought to you by Callum Chain and Luke Sadkovich. How are you, Callum?
I'm good. We're back from a week off.
It's just too busy last week, to be frank. We just had too much going on. So good place to be, and things have settled down this week, which is nice. Still a lot on the plate, but much more manageable.
Time to take a bit of the day to read some case law, which is always a pleasure.
Yeah, and I feel like we've had a string of cases in and around redelivery relating to vessels in the shipping law space.
And kind of higher payments and issues around what qualifies as off hire. We had one of those maybe a month ago or 2 months ago. And then this one's on the rate of losses at the end of a charter party, whether you can continue the rate of hire into another into further time used to clean the hull, but all kind of around those technical points of when is hire payable, and then what happens after the ship's redelivered.
Yeah, and also contract construction. How often do we find ourselves in these cases looking at principles of how to interpret what parties actually meant in their clauses, and then the consequences of the language that they've chosen to use?
Yeah, more or less invariably. Exactly. It always comes down to the terms, to the wording that's used. And this, I thought this was an interesting one, right, in that sense too.
It highlighted some issues to me that I kind of been in and around before, but perhaps not exactly on this point. And it is funny, after how many years we've been doing this, Callum, that there are still cases that come up. This wasn't a complete surprise or anything, but it just, I don't know, just in some of the language that was used, I thought, oh, okay, yeah, I can see that point. And I'm not sure I'd focused on that and what the word time means in this context, quite like this case deals with it.
And this is a case where I'm not wedded to either side. In all honesty, I think that you can quite sensibly argue one way or the other, and I'm not really surprised that this one came through on a Section 69 appeal. This was originally a case in arbitration. It came through to the court. The court upheld the arbitrator's view, but you can see how the court could have gone the other way. Indeed, you can see if this one did go up, that the Court of Appeal could take a different direction on it. But but at the same time, I certainly wouldn't say that I disagree with the court or disagree with the tribunal. It's just one where you can easily see it from both perspectives.
I completely agree. I'd kind of describe the way that I read this judgment as starting off thinking that the answer was going to be one direction, and then coming to realise why both the arbitrators and now the judge have gone the other way, and agreeing with it ultimately.
Yeah.
But I do agree with you that it could certainly be argued sensibly in both directions. And we're not talking about a whole lot of money here. And often in those cases, they're the hallmark cases for ones that could be argued in both directions pretty firmly. So before we get into it, to give everyone the citation and the case name, we're dealing with the Smart Gain Shipping, like that name, Smart Gain Shipping and Langlois Enterprises case, Smart Gain being the claimant appellant. And this case it's a recent one, right? It was only handed down on the 5th of July, 2023. Neutral citation number is 2023 EWHC 1683 COM. We're in the Commercial Court of England, and as Callum mentioned, we've got a High Court judge, Sir Ross Cranston sitting as a High Court judge, who gave a decision on an appeal from a decision of a London arbitration panel. So, where should we kick things off?
I was thinking we would start with paragraph 1 of the judgment.
Paragraph 1, yeah, there's a good place to start.
Exactly. Why not start at the beginning? And I think it's quite a nice paragraph to set the scene. Sir Ross Cranston says, the short point which arises in this arbitration appeal is whether under a clause in a charter party, the owners are entitled to claim the hire rate and related expenses for the time used for cleaning a vessel's hull after the charter has redelivered it, or whether they are confined to a claim in damages for breach of the charter party.
If we had this case and we had one of our trainees coming in, or a junior associate, and said, look, this is our case, and we start with that opening paragraph, and I said, now tell me, which direction do you think the market was moving?
Yeah.
What would be your answer?
Yeah, this is it. This would be a classic situation where the market is dropping. One party is saying you're stuck with the market rate, and the other is saying, no, I want the charter party rate for the overrun.
Which makes it, I think, an interesting case, because often we see it in the other direction as well. And we can kind of track where the market has gone in some of the cases that have come through to court, and think, well, about a year ago, probably, the market was coming off. And prior to that, if we go back and listen to some of our episodes from a year or two ago, when freight rates were going up, you kind of had the reverse argument here. And I think if you look at that and you think about these things in a different market position, and we should probably come on to this at the end, but I wanted to kind of sow the seed early, is how would this case be argued? Or it'd be interesting to think about how this case might be argued in a situation where the market was rising and not falling at the end of the charter. I think you should probably jump to clause 86, which is the hull fouling clause in this particular charter party. And I don't think we can emphasize enough in this case how important the language of the actual clause is. And as Callum says, that we're interpreting whether we're looking at a debt claim for hire, for the length of time that the vessel needed to be cleaned here, or a damages claim where charterers have to pay damages for the amount of time that it took owners to clean the vessel. So the context for this is that we have I think it was one trip time charter party, owners and charterers agreed that if the vessel remained in a warm water port for more than 25 days, and there was hull fouling, so growth on the bottom of the vessel, that it would be for charterers to clean that at their time and expense. And I'll read out the exact clause in a minute. But for those who know this area of law, this is kind of second nature, this stuff, the whole foul cleaning clause. For those that don't, essentially, owners here of the vessel are saying, well, look, if the vessel is stuck in warm waters for more than 25 days because of the way that charterers have been trading the vessel, using the vessel, then it's on you charterers to deal with that and the cost of that. We shouldn't be lumbered with the cost of cleaning it and the time that it takes to clean the vessel. That's on you charterers. And what's really important is, what are the exact words that are used by the owners and charterers in the charter party to allocate that risk, and how is that risk being allocated? So clause 86, should we just read that out?
Yeah, I think so. So clause 86 says, owners not to be responsible for any decrease in speed / increase in consumption of the vessel, whether permanent or temporary, by charterers staying in ports exceeding 25 days trading in tropical and 30 days in non-tropical waters. In such a case, underwater cleaning of hull, including propeller, etc., to be done at first workable opportunity and always at charterer's time and expense. After hull cleaning, vessels' performance warranties to be reinstated. And the really key wording here that the court's focusing on is that wording that says, and always at charterer's time and expense. In the context, as you say, Luke, of when this is not done during the charter period, I think I suppose one way to take this is, if this hull cleaning was done during the charter party, then I think it would be quite straightforwardly a period of a period where charters would the ship would remain on hire for the hull cleaning, despite the fact that charters wouldn't have the use of it, and charters would have to pay for the hull cleaning as well. So in the case where the hull cleaning takes place during charter, you have a situation where charterers are basically paying for the time because they're continuing to pay higher under the charter, and they're paying for the work because they're paying for the hull cleaning. So the question is, what happens if charterers fail to clean the hull during the charter period, such that their kind of obligation to pay higher has ceased on redelivery? Can the owners then claim against charterers at the rate of hire for the period after redelivery at which the hull cleaning actually takes place?
And there's a few points to kind of note in that clause, which we will come back to. But while we're on it, I think it's worth highlighting. There's this kind of key clause in the middle there. So the second sentence, in such a case, underwater cleaning of hull, including propeller, to be done at first workable opportunity and always at charterer's time and expense. And as Callum said, always at charterer's time and expense is the key phrase that we're looking to interpret. Also, to be done at first workable opportunity. That's another key aspect of that sentence. And then importantly, from charterer's perspective, they were emphasizing that this second sentence is kind of wedged between two other sentences in the clause that would suggest that this clause operates during the charter period and not after. And that actually, it's a interesting argument that the actual placement of that sentence in what we kind of wedged between two other sentences has some meaning in and of itself. And so charterers were arguing here that you look at this clause if you're dealing with a scenario when the cleaning takes place during a charter period. If the vessel has been redelivered, you're in a different scenario. You're looking at a failure by charterers to redeliver in proper condition. You're not necessarily looking at this clause for the effect. You're looking at a damages claim for perhaps a number of different breaches.
Yeah, I think it's one of those where you can tell there's been a huge amount of thought going into this reasonably short clause, and it's always interesting to see the results of that kind of really detailed analysis on, well, this could mean that, this could mean that. One of those great construction arguments where you're just really pulling apart every word of a clause. I have to say, before reading the clause, just after reading paragraph 1 of the judgment, I was of the mind that this would be likely to be a claim in damages, not an extension of the rate of hire.
And that's where I started too. I thought if you asked me this in the abstract, what would be the consequence of this factual scenario without looking at the specific clause in a great deal of detail. Of course, that's problem number one. But just what would usually happen here? You would say, "Oh no, this is a damages claim. If it's been redelivered, it's not in good condition. It's damages. You don't get extended hire." And often, as I said at the outset, if the market's going up, you're gonna get owners arguing this sounds in damages. It's a breach. We don't only get the higher rate. We want to claim the higher market rate because we're losing out on the next fixture. I agree, and that was my starting point. And then it's like, well, hang on, we have a specific clause here. Does this clause kind of create a bespoke approach in the context of this charter party? And that's really what we're looking at, is to see, have the parties agreed to something that might not typically be the case.
Skipping ahead to the award from the tribunal, they took the view that you effectively do extend that charter party hire rate across to when the actual work took place, or when the actual hull cleaning took place. And the key part of their decision was paragraph 17 of their award that said, "It is quite clear from the language of clause 86 that the intention of the clause is to assign that risk to the charterers and make them responsible for the time and cost of remedial action while suspending the vessel's performance warranties in the meantime." I suppose that's the departure point for the tribunal on clause 86. And they say, effectively, it's very clear in clause 86 that the intention is to put the risk on charterers. So charterers are responsible for time and cost of remedial action. And from there, there's kind of the next step in the thought process is to look at whether or not there's any authority supporting the owner's argument, which is that the rate of hire should be paid. And there's this case called the Nicky R, which I have to confess I wasn't aware of before reading this case, but it's an interesting one, which deals with a slightly different situation. I think it dealt with stevedore door damage rather than hold cleaning or hull cleaning. And in this case, effectively the Nicky R, despite being on a different issue and different facts, was reasonably closely related to this case in the sense that you have one party who's trying to use the wording of the charter to transform a claim from one in damages into one in debt. And effectively, that's what owners are trying to do here. They're trying to say, you don't owe us damages for our loss. You don't owe us damages for the loss that we suffered in remedying the unclean hull. What you owe us is a debt for the cost that we incurred in cleaning it, plus the time that we spent cleaning it at the charge party rate. And if you read the Nicky R through that lens, then it actually is a pretty good authority, and gives owners here a fairly clear run to argue that they're entitled to claim this as a debt.
It's not easy to wrap your head around when you're thinking that the cleaning didn't take place during the charter period. Owners have a debt claim against charterers. That cleaning could take place at some indeterminate time down the track, presumably before the next charter. And there's some discussion about that, whether practically speaking, or even legally speaking in the context of the next charter, whether owners would have to get the vessel into the satisfactory condition and clean the hull prior to delivering into the next employment, or whether they could do it while waiting in the next employment. And that raises the prospects of double recovery and what have you. But the time that's actually going to be incurred cleaning the ship could happen well after the charter period has ended. And then that time, as I understand it, the time actually spent cleaning the vessel is going to be the time used to then calculate the debt claim that owners have against charterers in respect of a contract that's already, in respect of a charter period that's already come to an end. It is conceptually, so you've almost got, like I think of things in a linear kind of way. You kind of have you've got a charter period that runs from X to Y, and then you've got sometime after Y plus 10 to Y plus 12, and that 10 to 12 over here kind of gets tacked on as additional hire to be paid to the original charter period. And conceptually, there's no reason why you can't do that contractually with language, and that's what has been found to happen here through this clause. But conceptually, that's a difficult kind of concept to get through, rather than a damages situation, because what's happening down the track is open to all sorts of other variabilities. And this is where I have some sympathy for what the charterers were arguing, in that I do actually think there's a prospect of double recovery here. Yes, in most cases, owners will need to get the vessel in sufficient state to perform that next fixture, but maybe they do have the benefit of the waiting time to clean, even if practically, if not legally, they're entitled to do that under the next charter. And the idea that you get that time irrespective of what the vessel is doing is an interesting concept.
And that was pretty much what happened in the Nicky R, where they had stevedore damage, and the stevedore damage clause said charterers to be responsible for damage to the vessel done by stevedores. All damages to be repaired after completion of the voyage at charterer's expense but in owner's time, provided that such damage does not affect vessel's seaworthiness. And I can't remember exactly what the facts were, but there was the repairs were done to the ship at a time where the ship would, in any event, not have been trading. And in that case, the charterer said, yes, we're responsible for the stevedore damage, but no, you didn't suffer any loss in terms of the loss of use of the ship, because you wouldn't have used the ship anyway during that period. And the court held, no, actually, you are liable to, the charterers were liable to the owners in a debt, because they'd agreed that the repairs would be done at charterer's expense, but in owner's time.
Yeah, and you can see how commercially that might make sense, why the parties could agree to allocate the risk in that way, because what it does effectively is it incentivizes charterers to get that vessel cleaned within the charter period. Now, in this context, it was only a short time trip, and that was a factor leaning in owners' favour as to why this should be what hire should run. But you can see in a longer time charter that may run over subsequent voyages, that this incentivizes charterers to clean the hull at some point when the vessel might not be doing anything and it's waiting, and to get it done, rather than just say, okay, this is owner's problems, we'll deal with damages as and when, and then make it an owner's problem where they then have to find the time in the next charter or before they enter into the next charter to clean that vessel and bring the claim against it. So it does, it probably, arguably creates the right type of incentive.
Exactly. That was something the judge noted towards the end of his conclusions, and that reasoning stuck with me as well, Luke. I think it's exactly right. You don't want to be in a position where you're incentivizing charterers simply to make this the owner's problem. You want to be it makes commercial sense for this to be something where the parties have said, no, this is an issue for owners. For charterers. Charterers have caused this issue and they need to fix it. What this goes back to, though, Luke, is the question that you mentioned at the start, which is what if the market rate is higher than the charter party rate? Because then you're actually not incentivizing charterers to do anything. The incentive to charterers would be, don't miss out on the good bargain you have with the ship at the charter rate. Let owners deal with it afterwards, and they'll deal with it they'll have to deal with it at market rate time, but you can use the ship to the maximum at the preferential charter rate you have.
Yeah, I think that's right. It's an interesting point. One of the other aspects of this that I wanted to touch on, Callum, was and please do jump in if you think this is too long. But I actually really enjoyed reading, in large part because it relates to another case I'm working on as well. I really enjoyed paragraph 19 and the paragraph there on contractual construction. I thought it was a beauty of a paragraph. I know I've read it before or in different or parts of it, but I think it's worth reading. And this is a passage from the Ocean Neptune, the 2018 case of Mr. Justice Popplewell. And it was restated again in the Eleni P in 2019. I just think it's worth reading the whole thing out, because this is what you do when you have a contractual construction case.
Yeah, I fully agreed.
The court's task is to ascertain the objective meaning of the language which the parties have chosen in which to express their agreement. The court must consider the language used and ascertain what a reasonable person, that is, a person who has all the background knowledge which would reasonably have been available to the parties in the situation in which they were in at the time of the contract, would have understood the parties to have meant. The court must consider the contract as a whole, and depending on the nature, formality, and quality of drafting of the contract, give more or less weight to elements of the wider context in reaching its view as to the objective meaning of the language used. So I think you're just pausing there for a moment. There's some interesting elements there. There's some real, hallmark aspects of contractual construction. It's objective. You're not looking at what the parties subjectively thought, and clients often want to tell you, well, I thought this or they thought this, and actually it's an objective analysis. You're looking at a reasonable person. Now, the reasonable person will be clothed in the knowledge of the parties and what the parties can reasonably have been taken to know in that situation. You're looking at the quality of the drafting. Was it drafted by commercial parties? Is it drafted by lawyers? Is it clear? You're then looking at the objective meaning of the language that's used. And then going on, and this is where I think it's quite important. If there are two possible constructions, the court is entitled to prefer the construction which is consistent with business common sense and to reject the other. Interpretation is a unitary exercise in striking a balance between the indications given by the language and the implications of the competing constructions. The court must consider the quality of the drafting of the clause, and it must also be alive to the possibility that one side may have agreed to something which, with hindsight, did not serve his interest. Similarly, the court must not lose sight of the possibility that a provision may be a negotiated compromise, or that the negotiators were not able to agree more precise terms. This concept of, well, if you have two interpretations, and it's not always the case that you do have two open interpretations, you often do, but sometimes you don't even get into that. Sometimes there is a plain meaning of the words, and there's plenty of contract law on this, that if the plain words mean one thing and only one thing, you go with that, even if it's quite harsh on one of the parties. But when you have two interpretations, you do get into this business common sense and what makes sense commercially. And it's not always obvious, right? Because you have this, sometimes what might seem very commercially sensible in one respect could be being counterweighed, well, it was just a bad bargain for one of the parties.
Everyone will have a view on what is business common sense after the event. That's it's very easy to say, well, there's no way we would have ever agreed to something that gave us this massive liability when you're staring down the barrel of that massive liability. And I think that happens quite often when people bring up this argument.
It does. And also often when you start to, drink the Kool-Aid, right, and believe your own argument too much, you think, oh, this makes so much business common sense. And then actually you hear the other side say, well, from their business common sense, like, actually... You weigh it up. It's not as clear cut as you may have thought.
Exactly.
So business common sense only goes so far, I think. And what I'd say on this is, and emphasize, is look at the rest of the contract. So rather than the wider context of what would make sense out in the business and the wider world, which I think can sometimes stray into policy issues easily, look at what the actual contract was setting up as the commerciality. What was it kind of providing for is the business common sense, and then use that to interpret the particular clause. And this unitary exercise, so going back to the passage, this unitary exercise involves an iterative process by which each suggested interpretation is checked against the provisions of the contract and its commercial consequences are investigated. So that's what I was just saying, is you look at the rest of the contract and then use what's set up in the framework of the agreement to then explore the particular clause that where there's some ambiguity. It does not matter whether the more detailed analysis commences with the factual background and the implications of rival constructions or a close examination of the relevant language in the contract, so long as the court balances the indications given by each. I don't know. I just thought that was just such a good starting point for any contract construction case, particularly in commercial contracts like the ones that we regulate.
Yeah, I totally agree. It's and particularly knowing that this has come from a shipping case, that it's going to pass the sniff test in maritime disputes when you're reading maritime contracts, and it respects the balance of commerciality that you described earlier, Luke, where everyone thinks that their hindsight view of what was commercially sensible was objectively commercially sensible, and you have to weigh up, actually, let's look at this in detail. Is the way that you're saying this contract is formed, and what you're saying this contract does, and what you're saying that this contract means, is that actually something which is which, if given effect to, would be the more commercial view? the other point I would stress that I think you're right to raise is that you only get into this if there is really ambiguity. And the court won't find ambiguity where there's clear wording which is deeply uncommercial. And that was effectively the case of Arnold and Britton went to the Supreme Court, where there was a contract that, if looked at through a commercial lens, was certainly not commercial, but it was clear. And in those situations, you don't get to test the more commercial language. You're stuck with the clear language in the contract. But where you have these two competing interpretations, or these two competing constructions, one of which is eminently more commercial than the other, then this is a really good framework for thinking it through in your own mind as you undertake the constructive as you undertake the exercise of constructing constructing your argument around the clause.
Do we have any other kind of comments to make on the particular clause we're looking at here, or some of the reasons why the court went the way that they did?
Yeah, so I think a key word in it is that word always, because a lot of the dispute here was around the timing issue. How does this clause continue to apply after the charter party is done and dusted and the vessel is redelivered? And yeah, as we both seem to have thought when we read the introduction to this case, owners have an uphill battle in trying to say this isn't a damages claim, this is a debt claim. And it's really that word always that allows them to say, actually, it's not only a charterer's time and expense during the charter party period, it's always a charterer's time and expense. And therefore, the word always was relied on heavily to say that the clause had that effect. Taking your example, Luke, in kind of day plus 10 to day plus 12, even though it's happening at some point in the future, the effect of this clause is that it's always a charterer's time and expense. And I think that was is a sensible point to flag, and I think it's probably right that is the effect of the word always in this clause.
I think that's right. I think overall, it wasn't sufficiently clear, and to the contrary, there were enough markers in the clause for it to extend beyond the charter period, and also I think the arguments that they made just weren't strong enough. They couldn't get over the language of charterer's time. Like, what does time actually mean? Combined with always, and the arguments around placement of the sentence within the context of the other two. And at first workable opportunity. Well, first workable opportunity in the context of a short trip time charter party could well be after delivery or after redelivery. There just wasn't. There was enough in there for owners to say, well, this isn't limited to during the charter period. Now, just coming on to that point of if we were dealing with a rising market,
yeah,
would owners have been, and with this interpretation of Clause 86, would owners have been restricted to the charter rate, or would they have had a separate damages claim for not redelivering in good condition, and they could use that separate breach to get into damages, and not only be limited to hire?
Yeah, I find that really interesting, and I'm not sure that we actually get the answer from.
No, we don't. No, we don't. We don't. It's a tangent, which I know you know I'm guilty of.
I do think that there's probably also a breach there.
Yeah, I think so too. I'd have to think. I must admit, I haven't come to a concluded view on it. So someone will probably hold me to it the other way at some point. But thinking it through, it doesn't read like a clause. And of course, these types of arguments are always construed in the context of the particular charter party you're dealing with and the particular clause in the language. But I don't read the clause as being exclusionary in any way. And I think there's probably a separate breach there.
Could it turn on whether the hull cleaning was actually done at the first workable opportunity? I'm just looking back through the clause. I'm not sure it actually says that charterers are required to pay anything, or the charterers are necessarily in breach if the vessel stays in ports exceeding 25 days in tropical waters or 30 days in non-tropical waters. But there's definitely an obligation on charterers here to clean the hull at the first workable opportunity. So you could be in one of those situations where the question is, did they clean it at the first workable opportunity or not?
Yeah, but if you had a breach, right, and if
I was saying that would be the breach. To have a breach.
So you're saying if they did clean at the first available opportunity,
yeah,
then charterers could reasonably argue, well, we're going to pay the higher rate.
Or if they would have cleaned it, or if they didn't fail to clean at the first available opportunity. If there was no available opportunity until redelivery, then
exactly.
Then what's the obligation that they've breached? And because on clause 68, on clause 86, I see an allocation of risk more than an obligation not to have the hull fouled by trading.
Yeah, I agree. I think that's right. So if it got to the end, if the first workable opportunity was when the vessel got to the redelivery location and the vessel gets redelivered and it's not clean, then under this clause, charterers are entitled to take the first workable opportunity to clean. And yes, they have to pay the higher rate, but they shouldn't be whacked with damages because they're actually not breaching this clause. They're performing the clause. I think where it gets interesting is, can they redeliver? So I think the point there would be, well, charterers should not be redelivering. They should be keeping the vessel on hire, unless there's a redelivery date that they need to work within or something. But they should really just be keeping the vessel within hire, cleaning the vessel, and then redelivering after the cleaning's been performed. And then the question of breach probably doesn't arise if that was the first workable opportunity and they haven't breached the condition on redelivery obligation either. But anyway, we're doing what politicians hate to do, and that is answering hypotheticals. But it is fun.
But I think that would be what you just said would be consistent with the law on late redelivery as well. Because in a case of late redelivery, you pay the extended period of the charter hire, but not necessarily be liable for market movement in the meantime. Is that right? No, I think that's wrong. I think you'd pay the extra bit. I think I'll probably cut this bit out. Me failing to remember the law on late redelivery. It'll be interesting to see if this comes back up in another light with a rising market rather than a falling one.
Cool. All right. Well, I enjoyed that one. I think
that was
a neat little case. And thank you everyone for listening in. If you're hearing this, you've stuck with us. So thank you. We hope you've gotten something out of it. And if you've got any questions, always feel free to drop us a line, comments, arguments, whatever. We do receive them, and we do enjoy the engagement. So thank you for listening in. And if you'd like to follow us, subscribe on the channels, we'd be delighted to have you on board. Until next time, take care.
Cheers. Thanks. Bye.